Hi, Assalamualaikum and good evening. My name is Aila binti Shamsuddin and my matrix number is EX03520. So for the test to assessment, I choose the topic major and minor misconduct in employment. So let's get started. So what is misconduct? Case law have defined the meaning of misconduct to be any conduct on the part of employee which is consistent with the faithful discharge of his duties or any breach of the express or implied duties of an employee towards employer. It also known as a form of improper behavior or an intentional wrongdoing or a deliberate violation of a rule or standard of behavior. So progressive disciplinary action is a process whereby an employer takes disciplinary actions against an employer in progressive manner that is going from the lesser to heavier intensity action. So there are various clauses in the Employment Act 1955 that pertain to taking disciplinary action in a progressive manner. All misconduct and act of indiscipline must be investigated to identify whether they are minor or major in nature. The handling of misconduct and some of related clauses is regulated under Section 12, 13, 14 and 15 of the Employment Act 1955 and also in Section 20 of the Industrial Relations Act 1967. So there are two types of misconduct. The first one is minor misconducts. So minor misconduct can be described as any act of indiscipline or behavior by an employee that cause minimal harm or damage and is less detrimental to the reputation of the personnel and asset of the employer. And the second one is a major misconduct or as known as gross misconduct. A major misconduct is any act of indiscipline or behavior that cause substantial harm or damage, is detrimental to affect the reputation of the personnel and assets of the employer. Similar to minor misconduct, all major misconduct must be investigated. So the example of minor misconduct is absence without leave for a period of less than 6 days, engaging in personal work during office hours, absence or leaving assigned place of work without permission of his superior or manager, willful insubordination, refusal to work or disobedience, neglect of work assigned, failure to observe safe working practice, using company property for personal purpose, loitering, gossiping in department during working hours. So next, all complaint must be put in writing on a formal complaint form provided by a supervisor or the head of department. A warning letter should be issued if the same misconduct is repeated. The letter must state the misconduct and warn that serious disciplinary action can and may be taken against the employee in question if the misconduct is not corrected. Should the employee again commit the same misconduct, a second warning letter should be issued. So for the example in major misconduct is insubordination, disobedience, theft, dishonesty and fraud, going on legal strike or abetting, inciting, instigation, gambling, assault, violence, harassment, bribery, chronic inefficiency in performance, drug, alcohol abuse, destroying company documents. So, if the employee does not satisfy to the conditions set down, the employer may proceed to hold a domestic inquiry and to take a more serious disciplinary action against the accused employer, including dismissal. The employee should be given reasonable period of time to respond, for example, 5 working days to reply to a show cause letter, but may be extended if the magnitude of the event warrants a longer period of process, such as if it witnesses accounts need to be complied. A final warning letter may be issued if the reply is not acceptable. In situations where said misconduct persists, the employer may proceed with a domestic inquiry. How are we going to differentiate between major misconduct and minor misconduct? So first we're going to look to the Employment Act. So in Employment Act 1955, they didn't state that no reference to the words of major and minor misconducts. According to the company, like to differentiate major and minor misconduct by identifying the different types of punishment for both category of misconducts. And then the list of minor and major is subjective and might vary depending on the nature of the business. For example, the act of smoking might not be a major misconduct in a legal firm, but it might be deemed as major misconduct in an oil and gas plant. So the example of cases for the first one is Zulhilmi Fauzi versus MISC Berhad in 2014. So in this case, we'll talk about use of illegal substance. So in Zulhilmi Fauzi versus MISC Berhad 2014, MELRU5, an employee was dismissed after failing a random drug test. And then the employee was dismissed because he had tested positive for morphine, and there was no allegation that his work performance was affected or that he had acted inappropriately while under the influence of drug. The court found that the dismissal was fair since failing a drug test is major misconduct, which was clearly inconsistent with the fiduciary relationship between the employer and employee. It was reasonable to dismiss the employee because the safety of the other employees had to be considered and the reputation of the company had to be maintained. So the next case will be Ngiam Kiok Moy versus Pacific World Destination East Syndrome Berhad in 2016. It states about insubordination. So in this case, the appellant had been employed by the respondent since 1st November 1989. There had been no disciplinary issues with the employee prior to the actions which led to her dismissal by the employer on the 30th December 2009. So according to the employer, the employee refused to follow her superior's instruction to make payment for appropriate expenses and make adjustment to the company budget, and wrote an email saying she would not longer report to the said superior. So applying to the proportionality test, the Court of Appeal held that the High Court committed a grave error in interfering with the Industrial Court awards. The employer's decision to dismiss the employee was unduly harsh and grossly disproportionate to the gravity of the misconduct committed by the employee, and the employee had therefore been dismissed without just cause and excuses. So the Court of Appeal stressed that the management's prerogative to discipline its employee must be exercised in a manner which is reasonable and fair. Before dismissing an employee, an employer should consider whether a less severe punishment might be sufficient. So that's all from me, and thank you for listening.